Have you been told that add-backs are dead in property settlement? Maybe someone has said if your ex wastes money after separation, there's nothing you can do about it. Or the courts don't add money back in the property pool anymore. Recently, we've been hearing this a lot, particularly after the case of Shinohara and Shinohara. But the idea that add-backs are dead is actually a misunderstanding of what the cases and the new cases say. Today, Mum and I are going to unpack what add-backs really are, why people think they're disappeared, and how the courts are now dealing with the situation where your ex has wasted all the money or reduced the property pool. Because the reality is the courts haven't stopped considering wastage. Welcome, Mum.
Hello, Laura. Hello, everyone. That's a good topic, isn't it?
Yes. Before we get started, just a reminder, Mum is not your lawyer. I am not a lawyer. This is Australian family law.
Hello, I'm Laura, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
This is relevant to Australia.
Yeah.
Please always get your own independent legal advice, as this is just a discussion.
Yeah.
So, Mum.
So, after all of that.
What is an add-back in property settlement?
Okay, a little bit of history, okay? So, over the years, a practice has developed in family law where the court looks at the property of the parties, but it doesn't seem fair just to divide what assets there are available on the day of property settlement. But of course, that's when all property settlements are dealt with, on the day of the property settlement, and the values as at the property settlement. An add-back is usually of something that has disappeared, that would have otherwise been in the property pool, but one person has, or another person has disappeared, wasted it, given stuff away, whatever. And therefore the property pool is skinnier than it should be. And so the court would go something like, well, there's $100,000 in the property pool, but you, sir, like in Townsend's case, you have sold that taxi for $80,000 less than it was worth. So we're going to say you've already had that $80,000, okay, because it no longer exists. It caused the court a lot of heartache, but it seemed to be the only way to manage people's behaviour between separation and the actual property settlement. Now, that's what an add-back is. That's how that money gets taken away.
Okay, all right. So let's just before we go into the changes and what's what. So let's just add-backs could have been for excessive spending.
That's a tricky one. Yeah.
Legal fees.
Yeah, or giving car away. Legal fees are always
spending after separation, destroying assets, giving money away.
Yeah, spending on unreasonable things, giving things away. And so it was a complicated way of dealing with stuff, but they'd put it back in as an imaginary amount in the balance sheet. In that example with the 100,000 assets, that's in the balance sheet. A balance sheet's a list of all the assets. And then they would also add in the $80,000 that was wasted by him selling the taxi that cheap, and that goes in, right? And plus the $20,000 he got, whether he spent it or not. And then they'd say, that makes a property pool of $200,000 and you've already had $100,000. And he goes, well, I've only got $20,000. They go, no, you had $100,000. That was what the taxi was worth. What you chose to do with it is off your share. And it was a way of justice between the parties.
So really what you're saying, if they wasted, say, $50,000, the court would put the $50,000 back into the pool, imaginary, and it was on their side saying, you've already spent that, but that's your problem. That's on your side. Okay. Yeah. All right. So that's how it used to happen.
Yes.
Okay. So before we talk about the add-backs now, can we just quickly get a head around the property pool? Because you just said balance sheet and property pool. Are they the same thing? Property pool and balance sheet?
A balance sheet is where you write down what the property is. The property pool is kind of like a basket of the house, the everything you own, or either of you or both of you own. The house, the banks, bank accounts, furniture.
So the property pool is the name of the things, the assets.
Yes.
And then the balance sheet is the dollar value of
It's
the
where you
things.
write them down. That's right. So
Okay.
you put it in a
Okay.
balance sheet. What the courts are wanting, it's some of the pre-action procedures, they say, you guys work out what everything's worth and don't come to us until you know, right? And then
Right.
they have this thing of hopefully doing a joint balance sheet. And so it was common for people to go, we've got this, we've got this, we've got this, and then add backs, this, and that.
So really, in if anyone's never listened to an episode ever, step 1, you identify your property pool, all the assets, put it all in together. Then you look at your contributions and then your future needs, which we've talked about in other episodes.
Yes.
And we show you in our course. And then you got to make sure it's just and equitable. And
Yes.
then you usually put the add backs in the first step where you're identifying the property pool on the balance sheet.
That's exactly right.
So why are people now saying add backs are dead?
Because they misunderstood the effect of a case that was earlier this year at Shinohara, last year, 2025, of Shinohara and Shinohara, Shinohara and Shinohara. In that case, the full court said quite clearly, why do you put these things that don't exist in the balance sheet? Only put things that you've physically got in the balance sheet and stop putting stuff in that doesn't exist anymore. Okay. And they said, we've got the power to arrange property between the parties. That's the power we've got under Section 79 the Law Act.
So they were worried really that people were putting fake pretend money because it didn't exist anymore in the property pool, and the court doesn't have power over pretend money.
I think that's what they were getting at, yes. And also, too, an awful lot of time was spent digging up evidence by the parties of wastage, of add-backs, trying to find out what did they get for that? How much, like quite a bit of forensic looking into things to work out what these imaginary amounts should be, that should be, in their view, in the property pool.
Lawyers and people have read the case of Shinohara and Shinohara and seen where they've said, no, we're not dealing with money that doesn't exist.
Yes.
Don't put $0 that don't exist in the balance sheet. How did they come up with the idea that add backs are dead then?
I think in the case they actually say add backs are dead, but they didn't mean it in terms any other, with my respectful interpretation of their Honour's comments, they didn't mean that it doesn't get taken into account. They just meant stop putting it in the balance sheet because we don't know what we're working with here and we've only got power to distribute the existing property, right?
Mm-hmm.
So then...
Because the reason people are freaking out about this and the things that we're hearing is people are saying, my ex, he's gone and spent all the money on like a 5-star hotel holiday, first class tickets to Africa, climbed some mountain and wasted all this money. And I want it on his side of the balance sheet because it's not fair. And lawyers are saying, sorry, add backs are dead. The case of Shinohara and Shinohara say that is the case. And that's happening and people are hearing that a lot. And then why wouldn't then people just go and spend all the money they can as soon as possible?
Well,
before the property settlement.
Well, and they used to. They used to spend their money on living expenses and a bit more maybe. They wouldn't save because they were worried it would just get added to the property pool. So people were doing things to make sure that they weren't caught up in the property pool.
If add backs aren't being used the same way, add backs aren't being put on the balance sheet, what happens now then, and what can people say to lawyers who quote this Shinohara and Shinohara when their ex is wasting money?
Okay. So what they do now is they keep a pure balance sheet of assets, of things that you can see that actually exist. But that doesn't mean they ignore people's behaviour. So Section 79(5) of the Family Law Act, Section 75(9)(d) of the Family Law Act as amended for property settlement says, and I quote, the court should take into account the effect of any material wastage caused intentionally or recklessly by a party to the marriage of property or financial resources of either of them or both of them, right? It's now a factor that the court takes into account. but they take it into account in allocating the existing assets. In other words, what's left after this big spend up or whatever it is they've done.
So it's a percentage adjustment of what's left of the property pool.
Yes.
Okay.
And it depends on the size of the wastage, what they've wasted, compared to the size of the property pool, what percentages are awarded to the person who didn't do the wasting. Okay.
So instead of putting the wastage in step 1 in the balance sheet, then
they're looking at future, like they have it looking at the impact of their orders in current and future circumstances. So they're looking at what would happen if we divide the existing property based on contributions today. Is that fair or not fair? And if it's not fair, and one of the reasons it might not be fair is because one party's wasted the property. Okay.
Right.
Or because, age, state of health, caring for kids, all those other things, but now it's wastage as well.
So when we were talking about that $50,000 example, instead of now putting that back on the balance sheet, what they do is they consider adjusting the percentage of the property pool if it's
what's
appropriate.
Left. That's right. So in my taxi thing, I don't know the exact numbers. Say we got $100,000. And this is, if anyone wants to read it, it's Townsend's case, and there was also a case of Weir and Weir, where there was a big hole in a quarry, and they had to calculate what that might have been. So you still need to work out roughly what percentage they've wasted and what money they've wasted. But you do that sum on the side. And then when the court looks at these percentages, so you had $100,000 and $100,000 taxi, right? $100,000 cash, $100,000 taxi. The taxi's already been given to your ex, so there's only $100,000 left to divide. The court's going to go, how should we divide this 100? And they look over and go, well, he's had his 100 if it's 50-50. And they go, we'll give that person 100% of what's on the balance sheet to balance what happened, before. And that's exactly what happens now in that next case that we want to consider.
So the behaviour still affects the outcome of your case. Wastage still is considered. What is the case that people should be looking at if they get this Shinohara shoved in their face all the time?
It should be Shamon and Shamon.
Yes. It's 2 SHs.
It
SH
is.
for
and they're both,
you know what.
They're both made up names, of course,
yes.
because of anonymity. And so then Shamon and Shamon was a case, to paraphrase just briefly, it was something like this, that there was a property pool, I think of roughly 6 mil, maybe. I think that the person was an accountant, the one person, and he had access to a good deal of the money. He could get a hold of it. And so there were loans to family members, gifts to people, trips away, just blew the lot. And then went to court and said, basically, add-back's dead. Shinohara and Shinohara. And the court goes, no, that's not how it works. Anyway, so in summary, what they did was they worked out what had been wasted, right, and put that on the side. On the balance sheet, they just put what was left, and they awarded nearly every cent of what was in the balance sheet to the wife because it was roughly equal to what was wasted by the husband. And they said, look, it's up to you. If you recover those loans, if you've given them presents, that's your problem. You chose what to do with it. We're giving nearly all of this property to the wife. Oh, and by the way, because of your behaviour, you have to pay her legal costs, which happened to be just about equal to what was left in the property pool.
Oh, gosh.
So she got pretty close to 100%. That's paraphrasing it. So anyone who says to you, add-backs are dead or Shinohara and Shinohara, grab Shamon and Shamon and show them how it works. And Shinohara, with respect to my colleagues, not everyone's reading that properly. They just quickly glanced at it and go, oh, we can't do add-backs anymore.
But it still seems a little unfair because if you only can divide up the property pool that exists, even though you can get a compensation in a percentage for someone wasting the money, like if there's no property pool left, the court can't do anything. So what kind of warning would you be saying to people to be aware of, and what can they do? What should they do to make sure that they don't end up with them wasting the entire property pool?
I think move quickly to the lawyer, find out what your rights are, and then have a look. If you can see these things are happening or there's potential for these things to happen, you may want to get the case into court sooner rather than later. Don't let things drift. And sometimes people will, like a person who's got that in mind, might just keep the other guy at bay and say, oh, look, don't worry, I've got this, I'll look after you. All the time they're spending money, moving it around and disappearing money. And then by the time the other person wakes up, they've managed to disappear it. The court doesn't have power over things that don't exist. They only have power over the property of the parties. And that's always been the case, right?
And I guess we've talked about many times being in a gilded cage and this delay tactics. And a lot of people get caught up in this delay tactics where their ex is saying, oh, well, let's just take it slow. Let's not worry about things right now. I'll pay for your car. I'll pay for your rental. I'll just look after you that way. But meanwhile, they're squirreling away their business. They're making it worth nothing. They're, selling things to their friends and doing sneaky tactics. So that is still a thing that can still happen.
Yes.
And people need to be aware of that. So if you are getting delayed, you need to ask yourself, what are the delays? Is my ex likely to waste this money? How can I protect the property pool until property settlement? So what are some ways people can protect the property pool?
Well, depending on what state you're in, as in what jurisdiction in Australia you're in, you may be able to talk to your lawyer about putting a caveat on a property, perhaps if it's in the other person's name. And
does a caveat do?
Caveat is a warning. You heard of caveat emptor, buyer beware?
No, okay. No one's heard of that.
It's Latin, okay. It's Latin.
Okay. Of course it is. Everyone speaks Latin.
All the lawyers
Everybody.
do. Okay. So caveat emptor means buyer beware. And if someone's going to sell a property, and you're going to you're going to buy a property and you go, this looks nice, I'll buy this property. Your lawyer does the search and goes, hang on a minute, there's a caveat on it. We won't be able to process the transfer or take any steps in relation to this property until that caveat's lifted. And therefore, it's like a guard that you can throw up around. You've got to be careful, though. Don't use the caveats unwisely because there are consequences. So always talk to a lawyer about that.
Okay, that's houses, and the rules are different in each state for houses. What about just money in the bank? What if you're just seeing the money just slowly decrease? How can you protect that?
Well, if it's not in your name, you can't. Okay. If it is in your name or in joint names, you might take steps to require joint signatures, or you may take steps to take all or some of that money out, maybe. Talk to your lawyer. Don't take money out that's needed to run a business or anything. But, joint money is joint money and you can always give it back if you take too much. That's another thing that you can do. I think in the case of the taxi I was talking about, Townsend, and in the case of the quarry where there was $100,000 worth of gravel missing but no receipts, both of those parties, and Shinohara to be fair, and Shamon, all of them were lucky there was enough left to properly compensate them. I guess the court says, well, if they'd all been there, they would have got this much. Because of this person's wastage, they should still get this much. We're going to give that much to them. But, if you're in a situation where the only assets are being sort of disappeared and drained, then you need to move quickly. Get advice and move quickly.
And I guess that's the same for superannuation. Some people write to us in a panic saying their ex is spending all their super if they've passed the retirement age. We also are hearing of people who are selling cars and things like that for not much money.
To friends.
So how can you protect that asset?
Well, normally those size of things, the cars and things, there's not enough value in them for you to need to stop those sales, because there'll be enough other property to compensate you and you draw that bad behaviour to the judge's attention.
Okay.
But when it comes to superannuation, again, I've seen people who've had to go to court for the court to make an order that they stop drawing down on their super, and that gets served on the superannuation fund to freeze it. So you need not to be sleepwalking. You need to take steps, and if it means you've got to go to court for something, well, I guess you have to preserve it. But if the thing that they're mucking around with isn't going to affect the overall property pool like that you would get, the share you would get, then you might not bother doing something like that. Just kind of noted. I'll write that down.
So when you say bring it to the attention of the court to be like, hey, they've wasted money, I would like a larger percentage. A lot of people listening, Mum, they're not going to court. They're in mediation. Yeah. What kind of things do you say in mediation to make sure that you get an adjustment to percentage-wise for you for wastage?
I say Shinohara and Section 79(5)(d). And if they go, I go look at Shamon. And if I have to go to court, this is what I'll be getting. So as always, people negotiate under the kind of understanding that if the negotiations fail, you have to go to court. And if they think, well, I can either agree with that now and admit those things or agree with it in court and get stuck with costs like Mr. Shamon was. So, yeah, always it's just what the alternative is court.
Okay.
Back it up with law.
You take your Family Law Act, Section 79.
5D.
5D. You take that in. You take the evidence of their wastage.
Yes.
You take the Shamon and Shamon and Shinohara and Shamon case.
Yep.
And then you use that as your argument. And if they don't agree, then you say, well, we could go to court and this is the case.
I will be raising these. Yep.
Yes. Always go and check with your lawyer. Now, Mum, when we say go check with your lawyer, we have been saying that. And people have been saying, I checked with my lawyer and they said add-backs are dead. Now, we're saying add-backs aren't dead. It's just done in a different way. How can you respectfully, as a layperson who isn't a lawyer, who doesn't have a degree, tell your lawyer or their lawyer that they're wrong when they say add-backs are dead?
Okay. Respectfully, no greater respect than you owe to every other human being on the planet. And if that lawyer's wrong or you're wrong, you're entitled to have a robust discussion about the law. They're used to it. So if it's your lawyer, then show them Shamon and Shamon. And of course, remind them of Section 79(5)(d) and say, see, this is how it's dealt. If the lawyer is adamant that add-backs are dead, then I suggest you think about getting another lawyer because that person's not understanding the law. And if they become defensive about their wrong advice, that's a really bad look for a lawyer. Properly dedicated lawyer with your interests at heart. If for some reason they missed Shamon and Shamon when it came through, they'd look at it and go, oh, wow, oh, thank you for referring that. I'll read that more carefully later on. And then they'll probably be quietly kicking themselves for not keeping up to date. And if the lawyer's on the other side, you'll have it in writing. Maybe highlight the bit you need and just give it to the mediator to take to the other lawyer. I like to do it in paper, even though you've got your iPad or computer there, because there's nothing like sliding a bit of paper to the lawyer for the mediator, one to your ex who's in that mediation room, and the mediator can read it. And then they can all have that sort of, oh, I was wrong. Oh, I'd better give a bigger share.
Let's take it back even further than that. Say people aren't in mediation.
Right.
They haven't seen a lawyer yet, but they're seeing their ex watch misinformation out there. Mm-hmm. Spend it all now, sell it for cheap to your best friend for $1, all that kind of nonsense. What could they say to their ex if they start to see bad behaviour and wastage occurring?
You're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum, and family law accredited specialist to answer your question. All you have to do is go to www.thedivorcecourse.com and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today.
Let's take it back even further than that. Say people aren't in mediation.
Right.
They haven't seen a lawyer yet, but they're seeing their ex watch misinformation out there. Mm-hmm. Spend it all now, sell it for cheap to your best friend for $1, all that kind of nonsense. What could they say to their ex if they start to see bad behaviour and wastage occurring? Can they say to them, hey, just so you know, when we go for property settlement, I'm going to be asking for a larger percentage because you're wasting all this money?
Well, you won't say it. You'd write it to them.
What would you write?
Yeah, Dear Joe or Joe, I've noticed that Fred is driving around your old muscle car and he's told me that he got it for X amount of dollars. We both know it's insured for $120,000. So just so you know, here's a copy of Section 79.5. Here's a copy of Shamon, a link to Shamon and Shamon. Here's a link to Shinohara. Maybe don't give him Shinohara, just Shamon and Shamon, and say, over to you. But you're not getting away with it.
Okay. So it's a good idea for you to educate your lawyers if they don't understand. It's a good idea for you to educate your ex in the early stages. It's a good idea for you to act protectively and move fast if you suspect things are happening, because like Mum said, once the property pool's gone, it's gone. So you need to make sure there's enough in there for you to get it. And like you said, Mum, in Shamon and Shamon, she nearly got 100% of what was left, which would have been what she would have got in initially anyway, based on all the other factors.
That's right.
Yeah.
Probably she might have got a wee bit more, but not much. But what was important is the fellow with all the bright ideas and moving stuff around really got pretty well nothing except what he could claw back.
Let's quickly look at what is considered wastage. We kind of touched on it at the start, but what kind of things should people who are listening today be keeping an eye out for?
So apart from selling things cheap,
Yeah.
there's a famous case called Kowaliw and Kowaliw, where the husband in that case let some people live in the house, the family home. He moved out and they were going to buy the house. So he didn't charge them rent. And I seem to remember they trashed the joint. It took a long time to get them out. And not only did they damage the thing and it had to be repaired, but also I think it was several months where there was no rent coming in, and it could have. And it was all down to the husband actually had let these people in and made that quite silly decision. And that was really the beginning, I think, of court cases where the court goes, you know what, that's down to him. He did that. So we're going to make a percentage adjustment. Now, nothing's changed. So that's one sort of thing. Gambling sometimes is wastage. Just be careful, though. If it's something that they absolutely can't help, then it can tip over into something that's not their fault and they won't be punished for it.
Well, what about, we do get asked, is drinking wastage? That
No.
there are people that spend so much money on alcohol or drugs, so that's not considered wastage.
No. So here's the difference. When you're together, they may have spent a shed load of money on alcohol, but the court assumes you knew about that, you're fine with it because you didn't leave, so that's none of their business. Post-separation, most people, I would think, who are drinking are using their wages to drink, and that's their issue. And the court says in Gollings and Scott, you don't have to go into suspended animation.
Okay. Well, what about if your ex has a new partner and they're using the property pool to buy expensive rings, holidays, new cars, all of that stuff, lavishing them with gifts and diminishing your property pool for your property settlement?
Yes. So one case, famous case of Gollings and Scott, a fellow had spent $8,000 on an engagement ring for his new partner while he's still in court with his old partner. And there was a hell of a kerfuffle. And you can imagine how the wife felt.
Yeah.
But it turned out it wasn't bought with money that existed at separation. It was purchased out of his post-separation earnings. Therefore, the court said he's entitled to do that. Now, it would have been completely different if there'd been money in a joint account or even in his account prior to separation that he did that with. That would have been wastage. Okay.
Right. Okay. What about, so we've talked about destroying property. We've talked about selling assets below their value.
Mm-hmm.
We've talked about gambling. What about just reckless spending? What if you've got a partner who just can't help themselves and they just buy the most ridiculously expensive handbags or most ridiculously expensive holidays? Like, is that?
It's not during the marriage. It's not wastage.
No, but what if after separation?
Again, if they've used their wages, they can do what they like.
Mm-hmm.
But
if it's property
property that existed prior to separation, then that's a problem, and it will go into account like Shamon as wastage of the material, and the court will give the other person an increased share of the property pool to compensate for that.
Okay. So basically you're saying if it's intentional or reckless and money that existed during the marriage before separation, then that can be looked at as wastage. But if it's just ordinary spending, or if it's money from their own income from salary or whatever after separation, then that's not considered wastage. What about bad financial decisions? What if they decide to buy a theme park?
Stitch Farms, I've had to.
Yeah. What if they do that?
Post-separation, again, if they use pre-separation funds and they make a bad decision and the business goes down, that's their fault and it gets counted for them. If they use pre-separation money and buy a business and it does well, that comes into the property pool because it's an existing asset, okay?
Yeah.
So they may use money that was around during the marriage to buy a house. That comes into the property pool. It's not wastage. There's an asset. It's still there. It's something.
Gotcha. Okay. So realistically, Mum, the misunderstanding of add-backs are dead. Can you just put it to bed for everyone now as a soundbite that I can use later? Tell me, Mum, are add-backs dead?
No, they're not. Add-backs entered on a balance sheet, that's a no-no. They're dead. But add-backs in general are still very much taken into account. So wastage in general is very much taken into account, but just not in the form of an add-back to the property pool. What it does is increases the other person's share of the property. So we had a wobble where people thought everything had changed, and that was because the legislation came out. Then this case of Shinohara, and they thought, oh, this is how it's going to be from now on. But no, it always has been that the court will take into account behaviour post-separation. But this, I think, has it been? I suppose. Yet the court looks at were those expenses reasonable. They've always looked at that. But this makes it abundantly clear that wastage is to be taken into account.
What evidence do you need for mediation or for court? What things does the court consider as proof or evidence of wastage?
Oh, that's interesting, Laura, because all you have to do, assuming you're not the one who wasted, all you have to do is show the court that there was money and now it's gone and it went to them and we don't know what happened to it, right? And you can say to the court, that was wastage. It's gone. It's not turned up in any of the accounts that's been disclosed. So that's 100,000 is, wastage by them. They will generally say, hang on a minute, I needed that money. Here's my receipts. I spent this money on reasonable living expenses. And the court may say, oh, yes, 30,000 of it was reasonable living expenses, but you still wasted 70,000. So a lot of people spin their wheels and get very stressed trying to make their ex tell them what they spent the money on, right? But that's not your job. Your job is only to point out to the court that it was gone and make an assumption and invite the court to make this assumption that this money is all disappeared and it went on unworthy things and that there's no existence of it anymore. And then they have to come back if they want to. The onus is on them to prove that that money was used for reasonable living expenses or that some of it at least was.
Okay. All right. So add-backs are not dead.
Really, no.
Because wastage is looked at still. They just approach it differently. Wastage still affects property settlement. And instead of $1 add back, it's now a percentage adjustment. Is that basically a good summary?
I think that's right, Laura. If you had the same case, for instance, if you had that case with the taxi in Townsend and Townsend, if you had heard, if the court was to hear that today under this new legislation that came in last year and post Shinohara and Shamon, I think the outcome is the same. It's just the mechanism that's different. So nothing's changed.
So what are those two cases again? And what's the Family Law Act people should be looking at?
Okay. A Family Law Act 1975 and 79.5D, but 79.4 and 79.5, both of them in general, relate to married people. And Section 90 SM and following pretty well mirrors those. And so you look at that in the Family Law Act. The cases that you really need to focus on are Shamon and Shamon. You can look at Shinohara just to show them that it didn't mean what they thought it meant. And Weir and Weir, is the Quarry case, very old case, and Townsend is another old case. They're the leading cases about what used to be add-backs, but really could be called wastage. So that's your tool. That's your toolkit.
And realistically, the best thing you can do is be proactive and keep an eye on things. Don't let things drift and let this be a situation that you have to argue and prove. It's better for you to work quickly if you think your ex is going to be that kind of person to get your property settlement sorted before it does all disappear potentially.
Yeah, or get it started at least. And the minute you find out anything like this is going on, if you can do it safely, send a message to them saying, I see what you're doing, just to let you know. It's, that's wastage. I'm going to call that wastage. And here are the cases, read that, stop it. That might not stop them, but you've given them the warning, and then you may have to go to court. You may have to go and see a lawyer and take some urgent steps.
Well, I strongly recommend anybody who's in this situation to go see a lawyer. Now, again, unfortunately, if you're in a financially abusive relationship, you don't have any idea of the property pool or any of the money, then it's even more important to get your property sorted as soon as possible because they're the ones that can really move things around and be quite horrible. Now, Mum, I guess you could write on the cushion, add-backs are dead on the balance sheet, but wastage is considered in property settlement.
Wastage rules. Wastage rules. Yeah, just call it wastage and you're fitting in under Section 79(5) of the Family Law Act, and you're also recalling those other cases. So
we can just turn that on the other side of the cushion.
Yes.
We can have Shinohara and Shamon and Shamon on the other side of the pillow. Now, Mum, every month we read out a podcast quote, testimonial. No, what do you call it? A podcast review.
Right.
And when we do that, if you are the lucky person who listens to and has written this review, you can reach out to us at thedivorcecourspodcast@gmail.com and we can arrange a free chat with Mum for you. We've been receiving so many messages lately. It's feeling really heartening to hear. Mum, you talk to a lot of people in our course, and I guess I don't get to hear from the people listening. And it's been really heartening to hear that we're having an impact and we're helping, and I'm absolutely encouraged and spurred on for us to not stop, Mum, because people are saying we're helping. So I really appreciate it when you guys let us know because it means a lot to us. And you can pay us back by subscribing on YouTube if it's safe, or following us on Spotify or Apple, or doing a little 5-star review. It really does mean the world to us. But today's review is from Manal from Australia.
Yes.
And they wrote, empowering. Thank you so much for this. This is my second separation, and I really wish I'd found you for my first, though it was 12 years ago. So informative, and it gives great steps to be proactive. The last thing I want is to be a passenger again. And through your information, I'm proactive with realistic expectations. A great compliment to my lawyer. I now ask better questions, and I'm doing a lot of the legwork. So I absolutely love that review.
I love it. Yes,
I'm
love that.
so happy for you, Mandalja, that you are able to be proactive and use your lawyer a little bit better. So super happy to hear that. So if you can email us at thedivorcecourspodcast@gmail.com and you can have a chat with Mum for your second separation.
Look forward to it. Yes.
And again, Mum, I cannot thank you enough for all the lovely work you do for us and all the knowledge you give us. And I wonder how many noses we are going to put out of joint from this podcast episode.
To crash helmet on, Laura.
I love that
We're ready.
I just love it. I just think it's hilarious because I'm seeing the message out there and it's scaring me that people are being told this, and it's misinformation and unfair justice. It's not justice.
Don't get me started on equalisation of super, because that's a myth that's going around and it gets me going.
Well, if you want to go listen to that episode where Mum rants for 40 minutes about super and equalisation, you can go and listen to that episode as well. And a reminder, if you want to find an episode that's relevant to you, you can go to the www.thedivorcecourse.com.au/blog, and you can search or use the little tags, and it'll bring up any episode that's relevant to the topic that you're dealing with. So there's 306 to choose from.
Believe that?
Actually, by the time this comes out, there'll probably be more. But yeah, so definitely go and have a look and see what's relevant to you and listen to the ones that are going to help you out. So thank you, Mum, for your time. And we will see you guys all next week. Hang in there, everyone.
No worries, Sarah. Bye, everyone.
Bye-bye.
Thank you, darling. Bye-bye.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.